Alright, welcome to the Chapter 4 video lecture on mens rea, concurrence, ignorance, and mistake. But make no mistake, mens rea is the most important concept in this chapter. So mens rea is criminal intent, and this is a pretty complex issue. When we are looking at a person's motivations and intentions behind their behavior, it is something that happens on a case-by-case basis. And it's also just something that can be a challenge to navigate. Some of the specific challenges are that mens rea can be hard to discover and prove unless the defendant has made a confession. We are looking at their behaviors and presuming intent. Mens rea definitions can be vague or incomplete. We have multiple different types of mens reas that can be assigned to different crimes, and even sometimes different elements of the same crime could have a different level of intent. And then there's a difference between motivation and intent. So first things first, mens rea is Latin for evil mind. So this literally translates to evil mind. And proving a state of mind when we cannot see it is a challenge. Confessions are fairly infrequent. And so we are often put in the position of using circumstantial evidence to demonstrate the defendant had the required criminal intent. When we're looking at intent, depending on the statute, we're kind of looking for a different type of intent. So subjective fault requires a bad mind in the actor. So if we're looking at like receiving stolen property, that requires you to know that the property is stolen, and then you still buy it anyway. And that is knowingly, like you knew it was stolen, you still bought it anyway. You knew, okay? Subjective fault is often linked to immoral crimes and immoral behaviors. So for instance, abandoned heart or bad heart or wicked heart or depraved or diabolic malignity. These are all terms from statutes that are looking at the defendant's subjective fault. So if you see a fault-based statute that is using these types of words, you know that they're looking for kind of this, that this is kind of been deemed an immoral conduct, and that we're looking at the bad mind in the actor. Whereas objective fault requires no purposeful or conscious bad mind. For example, thinking about stolen property again, if you buy a tablet that you kind of think could be stolen, and you maybe should even know it was stolen based on the price or where it's coming from, a reasonable person would know, and you do it anyway. That is kind of this idea of objective fault. You are not purposely engaging in this action because you have this bad mind at that time. You are objectively engaged in a faulty, problematic behavior, and you're responsible for those actions. So, more crimes tend to have objective fault than subjective fault. So we'll go ahead and note that here too as well. And then the last type of criminal intent is strict liability. And this is the statute has no intent requirement. So if you engage in the action and the attendant circumstance, you are guilty of the crime. Again, drunk driving is a great example of this. If you drive while under the influence of alcohol or another intoxicating substance, we don't look to whether you had subjective fault, you purposely wanted to drive, or even that you objectively, that you knew better. We don't even ask those types of questions. You drove a car under the influence of an intoxicating substance. Therefore, you are guilty of the crime. So that's how strict liability works. Another distinguishing issue with intent is this idea of general intent and specific intent. So general intent is the intent to commit a crime, the intent to commit the criminal act. General intent is the minimum intent for a mens rea crime. It is the minimum standard. Specific intent only applies to those bad result crimes we talked about last week. Those crimes that have a criminal harm attached to them, like a homicide or a rape. Here, you have to have the general intent to commit the actus reus plus the intent to cause a harmful result. So, again, thinking about homicide with a specific intent crime, you have to have this general intent to poison the victim. And then you have to intend that that poison be lethal to the victim in however many doses are required. So there are two, actually kind of almost, there's almost like two different intents going on at the same time. You have to have the general intent to commit the action, to poison, to stab, and then for these more serious homicides like first or second degree murder, you also need to have the general intent, the intent or the disregard that somebody may die as a result of your conduct. Versus a general intent crime like burglary, if you intended to break and enter the dwelling house of another, we don't necessarily look that you hoped that somebody was inside or that you intended for, that's not as important. You intended your actions. Okay, so this is a little confusing. There's a lot going on. It's part of why mens rea is complex. Please reach out with any questions. Now, we're kind of working through the model penal code in this book this semester. So model penal code levels of culpability: purposeful, knowingly, reckless, and negligent. So let's talk about the differences here. Purposeful is the most blameworthy mens rea, and it requires that it was your conscious object to commit the crime or cause the result. It was your conscious object to commit the crime or the result. And your book has an example of somebody, and the question is whether or not they purposefully exposed their victims to HIV. The defendant was HIV positive. He did not follow the guidelines he was taught and trained on by the State Department of Health as to how to engage in safe sex, and multiple victims. And so the question is, was this purposeful? And the court finds there was plenty to find that it was purposeful, particularly when he told one of his victims that he said, she asked if he knew that he should be protecting himself and other people, and he responded, "I don't care. If I'm going to die, everyone else is going to die." So that's evidence of this purposeful intent, this conscious desire to cause the harm and purposefully expose his victims to HIV. So purposeful. Knowingly looks a little different. This is, we could almost substitute, don't do it, but we could almost substitute this for awareness. Are you aware that your behavior is likely to cause this harm? The model penal code sometimes says practically certain. Are you practically certain your conduct would cause a criminal harm here? So it's not the same as a conscious object. It's not the same as a conscious object. So for example, if a surgeon removes a cancerous uterus to save a pregnant woman's life, they are going to knowingly kill the fetus, but the conscious object of the removal was not to kill the fetus, it's to save the pregnant woman's life and remove the cancer. but there still is knowledge that the act is practically certain to kill the fetus. So there is a difference here. There is a difference here. So your book has an example, State v. Jancy, the defendant and his wife, the estranged wife of the victim. They got into a fight, and the estranged wife's friend let air out of the tire with a knife. The victim saw and gave chase, and the defendant, still running with his knife, jumped in bushes and was holding the knife still. The defendant jumped on top of him and was stabbed from the knife. And the question is, did he knowingly assault the victim here? And the defendant's argument is no, it wasn't knowingly. He was just holding it he had hoped that the victim would run by him and he would get away. Instead, the victim jumped on him and he was stabbed. The court finds that this was knowing, though. They specifically say that the defendant knew someone could be injured when they're running around with a knife. But so, okay. He was reckless here, and we're going to talk about what that means in a minute. But for this to be knowing, he would have to be practically certain that jumping behind this bush holding this knife would cause someone to be stabbed. And that isn't quite accurate. Instead, what we really have here is that he created an unjustifiable risk to somebody else, to somebody who would come along, him hiding behind this bush with a knife. He created a risk that somebody would get stabbed, and he disregarded it. So reckless people consciously create substantial and unjustifiable risks. So jumping behind the bush while you're holding a knife when you're running away from somebody is creating a substantial and unjustifiable risk. But it's not the same as knowingly, because he wasn't practically certain that somebody would get hurt. He just created the situation where the harm could occur. And the harm did occur, but it wasn't knowingly, okay? Again, gets a little bit confusing. So if you have questions, email me or come to office hours. Now, the last intent is negligence. This is an unconscious creation of risk. So it's similar to reckless, but it is less culpable because you didn't create the risk on purpose. So in this situation, maybe our defendant was running and they jump behind a bush and then they see a knife and they pick it up and somebody jumps on them. That would be more of an unconscious and unintentional creation of risk. If they're running away from somebody, they probably shouldn't pick up a knife that they find laying behind a bush. But at the same time, they didn't jump behind the bush with the knife knowing that. So it's a little different. There's also an example of the difference between reckless and negligent in the Coppersmith v. State case, where it was whether or not Coppersmith killed his wife recklessly or negligently. They're fighting. His wife fell off the porch, and he pushed her. She punched him. He grabbed her. She bit him. He kind of slung her off the porch, and she landed in a spot where there were bricks in the ground. He didn't know that there were bricks in the ground when he pushed her. And so the question was this negligent or purposeful? And this case, we don't get the exact answer. The court says, well, this could be either way. It really depends on what the jury thinks. They sent it back for a new trial. They could find either way that this was either negligent or purposeful. All right, so there's a lot going on here. This is conscious object This is awareness. This is being aware of you're creating these substantial and unjustifiable risks. This is where you're unaware that you're creating a substantial and unjustifiable risk, okay? So that's kind of the key watchwords here. Now, shifting down to strict liability. This is a voluntary action alone is enough to attach your liability. We're going to note, though, there's almost always an intended circumstance. Your book gives an example about open bottle laws, but driving under the influence of alcohol, statutory rape, these are also strict liability offenses. So prosecution only has to show the defendant committed the voluntary act, though, that caused the harm to prove the case beyond a reasonable doubt. Now, there is some critique of strict liability offenses and some benefits of it. The benefit is that these they're intended to protect public health and public safety, like no open bottles of alcohol in a moving vehicle. The penalties are usually they're usually misdemeanors or really low-level felonies. The critiques are, though, that we could maybe handle these where we do assess the defendant's blameworthiness. We should really only punish those people who are the most blameworthy, those who act with intent. And if we overuse the law, it loses some of its effectiveness. All right, so the third principle of criminal liability, so first is actus reus, second is mens rea, third is concurrence. This is the idea that the mens rea triggers the actus reus. And in a result crime, a bad results crime, criminal harm crime, that it triggers the harm. This is required for all crimes but strict liability crimes, but it is never an issue in a real case. It has to exist because of the way that the criminal law is structured, but it is not something that's litigated. An example is, let's say you and your friend are meeting at her house. It gets wet, rain, cold. She texts you that you can just go ahead and break the door lock and go inside, and that she'll fix it another day. If she's running late, she'll be there eventually. Once you're inside, you decide that you're gonna steal her tablet. Did you commit a crime? No, you were given permission to break and enter, and then after you already engaged in the act, then mens rea came to steal. So even though it kind of looks similar to a burglary, it's not, because your action wasn't triggered by the intent. The intent needs to come first. Okay. But we're not really going to talk about this again at all this semester. You might see an exam question or two, on it, but we're not really going to talk about it again. Now, causation is an important issue. There are two different types of causation that we need to establish. There's first is factual cause. This is sometimes called but-for cause, and the question is, if it weren't for the defendant's conduct, would the result have occurred? Okay, so but for the defendant's action, would the criminal harm have resulted? If the answer is no, then we have established it. If the answer is yes, then we need to do some more work here. This is different from proximate cause or legal cause, though. This is more our subjective question of fairness. It's kind of tied into our due process rights. This asks, is it fair to hold this defendant responsible for this criminal harm? And usually the answer is yes, but sometimes we have something called an intervening cause. And this is something that interrupts the action and the harm, that makes someone less responsible. This often in the actual cases, if you were to get in, you see a lot of medical examples where somebody would have probably made it, but the anesthesiologist over administered a drug or someone administered a drug that the victim was allergic to, and they died from that, not whatever sent them to the hospital. So then it's not necessarily fair to hold the defendant responsible for a death that would not have happened except for this intervening action by somebody. But there's also other examples. Your book has one with an example of an assault on Xavier Bauer. This looks at the defendant's his girlfriend's child. The defendant's girlfriend's child took his gun to school in his backpack, and it discharged and shot another child. And the question is the defendant responsible for the gunshot wounds inflicted by his girlfriend's child, who took the gun to school unbeknownst to the defendant? And you see a lot of great explanations of this idea of fairness here. Is this fair to hold this defendant responsible, or is he too far removed from the harm so that it becomes unfair? And there's actually a majority opinion and a dissenting opinion, so you see that the jurists are actually split here. So causation. Now, we've talked about failure-proof defenses last week as well, but we're going to bring them up again. So remember, failure-proof defenses look at the defendant isn't presenting one of those affirmative defenses like self-defense or insanity. What they're doing is saying, you, prosecutor, did not meet your burden of proof. You didn't prove every element beyond a reasonable doubt, therefore I can't be convicted. Underneath that, the ignorance maxim sometimes comes up. This is the idea that we presume you know the law you're breaking. So ignorance to the law is not a defense. So that's kind of like something that has become kind of in pop culture. So that falls under here. Additionally, a mistake of fact is a defense. So the defendant can show that a mistake of fact occurred. This will prevent the formation of mens rea, which means the prosecutor cannot prove that element beyond a reasonable doubt. This doesn't work. Mistake of fact does not work for a strict liability offense because the prosecutor just needs to show the action. But it does work for an offense that has a mens rea. If a mistake occurred that prevented you from forming a mens rea, you can't be convicted of the offense. And so again, these failure-proof defenses are, you kind of let the defendant show that they didn't establish. Your book has an example of a failure-proof defense that looks at a conspiracy to procure unlawful voting and to commit forgery. Somebody used their bar to let people, as an address, let people register to vote from. I think that it was to change a zoning ordinance. And so the case is like, was there a mistake that prevented the formation of mens rea? And this is again, we don't get an official answer, but they do say that the person is entitled to present evidence that this did happen. The Model Penal Code, again, just reaffirms this. Mistake matters when it prevents the formation of mens rea required by criminal statute. Your book also talks a little bit about some of the academic scholarship out there, namely that looking at conviction patterns and how that our perceptions of morals and morality influence who we think should be convicted, as well as sentencing patterns and the defendants that we view as engaging in immoral behavior, we sentence more harshly than those we view as engaging in non-moral behavior. So it's just a nice way to tie in some of the research. I think these studies were conducted at Princeton University, and the defendant was they gave two different scenarios. One was about trafficking heroin, and the other one was buying concrete that they should have known was not acceptable. So we see just kind of how those differ as far as what our perceptions of the crime look like. All right, so biggest picture thing that I really hope is clear are these 4 types of mens rea: purposeful, knowingly, reckless, and negligent, as well as the difference between a crime that requires mens rea and a crime that is strict liability. Additionally, these types of criminal intent are something that will likely show up on your exam. So make sure you understand those. If you have any questions, if you have any thoughts, feel free to let me know. I look forward to hearing with you, and I will see you next week.